Well, good afternoon and welcome back to our Achieving More Together Today series. This is Blair Marvin. I'm Vice President of the Augusta Metro Chamber of Commerce. We're glad you could join with us today. This webinar series that we conduct Tuesdays and Thursdays is part of our overall initiative for our Achieving More Together Today concept. We also send out daily email communications and social posts and are really doing everything we can to help our members and our business community at large feel engaged and informed and stay positive. So we hope that you will reference our website for these other communications that have been occurring and other webinars that we've been doing, and also anticipate keeping an eye and ear out for them each day and as we move on into the coming weeks. We are honored to be joined today with Ed Enoch and Ed Tarver of Enoch Tarver Law Firm. Hi guys, thanks for joining us.
Sure.
They are bringing you steps to protect your business against future COVID-19 related claims. They will bring the perspective from the internal and your employees, things to think about and consider from that perspective, as well as externally with your customers and clients. So without further ado, I will turn it over. Thanks again for being with us, and thanks to Ed and Ed for presenting.
Thanks, Blair. Thanks for the introduction. As Blair indicated, my name is Ed Tarver. My partner is Ed Enoch. We are with the Enoch Tarver Law Firm. We are a full-service firm, and we are capable of handling all of your business and individual needs. Ed and I are both veterans. I'm an Army veteran. He's a Navy veteran. We both did our time in the military in service of our country before attending law school. I'm licensed in Georgia. Ed is licensed in South Carolina and in Georgia. Just a little bit about my background. I attended the University of Georgia's Law School. After leaving Georgia, I clerked for the federal court here in Augusta before starting my practice with what was formerly Hull, Towel, Norman, and Barrett, is now referred to today as the Hull firm. And while I was at the Hull firm, I was elected 3 successive times to the Georgia State Senate before President Obama appointed me to be the United States Attorney for the Southern District of Georgia. After leaving the Department of Justice, Ed and I decided to start a practice together. You know, Ed's been in private practice a little bit longer. You know, he came to Augusta after graduating from Washington and Lee Law School. His focus is on representing small businesses, and he's done that for over 25 years. He started his own firm in 2006, and he and I started partnering together in 2017. I'd like to, before we start this webinar, would like to make a small disclaimer, and just to share with you that the material we discussed during this webinar is for legal informational purposes only. It is not legal advice and is not intended to constitute legal advice on any subject matter. You should not act or refrain from acting on the basis of any content included in this webinar without first seeking legal or professional advice from someone else. With that, I will hand off to my partner, Ed Enoch, and he'll get us started.
All right, thanks, Ed, and thanks for the introduction. So, as Blair said, when we started thinking about the potential liabilities that can arise from this pandemic and the spread of this virus, we looked at it and said, well, we think there are internal threats to the business. There are external threats to the business. As Ed said, I've represented small businesses for 25 years, and years ago had one of my clients say, it would be great to be a small business if you just didn't have customers and employees, right? If you didn't have them, it'd be much easier to run. So those are really our 2 areas of focus of potential liabilities. I'm going to focus on the internal potential liabilities. Those are, what can happen based on the way you handle your employees, and then Ed's going to talk about the external potential threats. We're all aware that we're in a shelter-in-place environment. We're going to be there for an unknown period of time. that is really based on state and local orders. So I want to first talk about some laws that have passed since the coronavirus started, since we identified this as a pandemic and a national emergency. There have been two major pieces of federal legislation. I want to quickly go over each of those because I think there are some pitfalls if you don't follow those laws, or you don't know what your obligations as an employer are. The first is the first bill that was passed, the Families First Coronavirus Act, was early on out of the gate, middle of last month, and that instituted two things. One is paid sick leave, and the other is what they call an emergency family medical leave provision. This is catching people unaware as I talk to clients, because we're all used to the family medical leave only applying to employers over 50 employees. So a lot of small businesses, most of the small businesses in Augusta, they're under the radar. This law specifically applies to all employers under 500 employees. Now, there is a provision that says if you're under 50 and it's going to cause significant damage to your business, you may not have to follow these rules. But I will tell you that there is no guidance so far about how you opt out of this. So I'm telling people, you want to go ahead and act as if this law applies to you. So the first is 80 hours of paid sick leave. Every employee is entitled to 80 hours of paid sick leave. There are 6 reasons that they can use that sick leave. There are basically 3 reasons related to having the infection themselves, having a coronavirus infection. And then there are 3 related to taking care of other people. So if your employee has been told that they have to quarantine themselves because they've been exposed, or if they have symptoms and they are seeking medical treatment, that's in the first category, and they're going to be entitled to full pay. If they're staying home to take care of someone else, they're entitled to 2/3 pay. Now, the good news is the federal government is essentially paying for this leave, because the employers are going to get a tax credit to honor this leave. So it's not going to be any really out-of-pocket costs for employers. But I think there's some real potential liabilities if you don't know that you're supposed to do this, and people start coming to you and saying, I want to stay home, and you say, oh, well, I don't have paid sick leave, or I don't allow family medical leave, I'm not big enough. Well, you're wrong, because right now it does apply. The 3 reasons that you can stay home for other people, the one that most people are going to fall into are if you're staying home because your child's school or child care is closed, then you can draw this 80 hours of paid sick leave, but you're going to get it at 2/3 pay. That's the paid sick leave, 80 hours total. There's some maximums, daily maximums on that, but basically you just know that you have that potential obligation. The other is emergency family medical leave. That is 12 weeks of Family Medical Leave Act leave. It can only be used for one reason, and that is to stay home to take care of a child because their school or child care is closed. So the other is much more complicated. This is really very straightforward. They get 2/3 pay. They're entitled to it for 12 weeks. The first 2 weeks, you don't have to pay them because they can take sick leave. Right? So those are 2 new laws that I think have kind of gotten overwhelmed and bypassed by the second law that was passed, and that is the CARES Act, and that's the loans that everybody's getting, the Payroll Protection Act loans, the EIDL loans. This is the law that created the $500 add-on for employees who are furloughed or reduced pay. So that law, again, I think creates some potential liabilities. For one thing, because with unemployment, if right now in the state of Georgia, all employers are mandated to report people who are underemployed or have been furloughed because of the coronavirus. So normally Unemployment is you let somebody go, you lay them off, they go down and file Department of Labor. Now it is mandated that this employer has to do that. And the good news is it doesn't count against the employer in their rating for unemployment. The bad news is if you mess up and don't do it, they can assess you the full benefit that you have to pay. So if you don't file as an employer and the employee goes down and either an online files and gets the benefit, the state's going to charge the employer for the full benefit, where otherwise they would have been scot-free. The payroll protection loans. I think that everybody's rushed out to get these loans because you're entitled to get basically 2.5 months of your payroll. If you spend it correctly, it's going to be forgiven. That's the if. I think that's where the rubber's going to meet the road, is people have to make sure that they're spending this money the way the Small Business Administration is ordering them to do it. And that guidance is changing almost daily. Big idea is you have to spend at least 75% of that on payroll. You can spend 25% on it on rent, utilities, and interest on a mortgage. Those are the only other 3 things you can spend this money on. If you don't spend it right, if you use it for other purposes, it's not going to be forgiven. So you're going to end up with a loan when you thought you were being given a grant. The other thing is, and I've heard people talk about doing this, well, hey, this is, it's a 1% interest loan. Even if it's a loan, I'll just go take it out and put that money in the market or go to Vegas or something and whatever. Well, if you intentionally misuse this money, the SBA can come back against the employer, the person who signed the application, for fraud, criminal fraud charges, and they can demand the money back, the money that you don't have because you went to Vegas and you lost it. So those are our big, I think, liabilities. A couple of other things, just talking about, like, I know a lot of people know about HIPAA and they know about medical privacy. Employers, as a general rule, unless you are a healthcare provider, you're not covered by HIPAA. So if you have information about someone who's infected, then you don't have a HIPAA requirement to keep that private, but you may have a privacy problem if you disclose that information to other employees. So you have to be careful about how once you've identified someone in your workspace that may have the virus, how you communicate that is very important. So, all right, those are the internal threats. I'm going to turn it over to Tarver to talk some about the external threats.
Thank you, Ed. We wanted to talk to you about some external threats based upon the calls that we have been fielding from clients. Probably the number one inquiry that we get relates to the obligation of the employer. What's your obligation to safeguard your customers? Do you have an obligation to safeguard your employees from contracting the coronavirus? And what we are talking to clients about is, obviously there's a general duty under the OSHA Act. It actually is referred to as a general duty clause of the OSHA Act, where employers have the responsibility to provide a safe and healthful workplace that is free of serious recognized hazards. We all are aware of the coronavirus. We know about or we should know, or either we know or we should know about the information that's being provided as to things that you should do to protect yourself and to protect others from contracting the virus. Wiping down surfaces, thoroughly cleaning areas, not exposing unnecessarily customers or employees to the risk of contracting the virus. You may wonder, if you don't know, that OSHA applies to all businesses. In some cases, they will give an exception for record keeping to businesses with 10 or fewer employers, but for the most part, otherwise it applies to large and small businesses, and they are expected to meet the OSHA regulations. In addition to the OSHA standards in Georgia, as it relates to employees, all employers have a duty to exercise ordinary care to provide safe working conditions and to do those things that are necessary to protect their employers. And that's part of the Georgia statute. In addition to that, in Georgia, a business owner or an occupier of a facility has a duty to exercise ordinary care to keep premises and approaches safe. And so you can anticipate, or we anticipate, that we will see some claims against business owners related to this pandemic. I think that from my litigation experiences, I think there's a high threshold that they're going to have to overcome in order to prove those cases, but I certainly would expect that we'll see some of them. And we're starting to see some already. You know, I wanted to throw out an example of or a description of what ordinary care means as it relates to the obligation of a business owner. Ordinary care is that degree of care which is exercised by an ordinarily prudent person under the same or similar circumstances. And some examples of some early lawsuits that have been filed as it relates to this pandemic. There's already been a lawsuit filed against some cruise lines alleging gross negligence for allowing passengers to be exposed to COVID-19. It alleges that the cruise line owners or operators were aware that the ship had been exposed to COVID-19 and that they set sail with people aboard, even with knowledge that there was an infection on board and that others could be harmed. It's going to be interesting to see how that suit comes out. And then as it relates to actions by a business owner, there's already a business that has reported that they discarded $35,000 worth of food after a customer coughed on some fresh produce. Now that's more of an insurance claim, but I can tell you universally across the country and probably across the globe that insurance companies have now taken a position that there's no policy out there that recognizes claims for this type of pandemic or resulting from this type of pandemic. But you can see even early on that claims are starting to surface as it relates to the pandemic. Another call that we get or that we have received relates to business disruption, potential claims against your carrier for business disruption because either early on the local government has issued shelter-in-place orders that disrupted your business. You didn't fall within the category of a necessary business, and so you lost your business was disrupted, and you had some business losses related from that. And then after the local government's shelter-in-place order came the probably more fully enforced stay-in-place order from the governor of Georgia, in which he had actually had the Georgia State Patrol who were on standby to enforce violations of that stay-in-place order. This is right now, it's going to be, I anticipate it'll be a highly litigated issue. As I said that, you know, I've had conversations with some financial institutions and some other businesses who have contacted their carriers about coverage for business disruption, losses related to business disruption, and universally they've all been rejected and been told that there's no coverage. Now, every day I see more and more written from attorneys who are ready and prepared to challenge that, and they are pointing out areas in policies that we may be able to use to challenge those decisions. But there have been no decisions on those right now. The thing that I would tell you right now is going to be very fact specific and based upon the express terms of whatever your individual policy is. So if you have any concerns about that, you're certainly going to want to have somebody review your policy and to go over the facts, specific circumstances that lead you to believe that you have a claim. And then finally, it was another issue that we we have encountered a number of times since this involvement with the pandemic as it relates to contracts and whether or not there is any excuse for not performing a contract. And what we are asking folks to consider is whether or not their contracts have a force majeure, and I may not be pronouncing that right, but I'm from the South, so I'll take that exception. But a force majeure provision in the contract, and that's going to be require you to rely on the express terms of the contract, and they're generally never implied to be a part of the contract. So the first thing you're going to want to look at the language in your contract and to see if you have specifically expressed in the terms of your contract that provision of that language in the contract. And then even if you do have that language in the contract, you're going to want to know that it generally only applies to unforeseen circumstances that prevent an entity or a person from fulfilling a contract. The circumstances that you're relying on have to be outside the reasonable control of the party asserting the provision, and that it prevents the party from performing its obligations under the contract. And then it takes a step further. Generally the affected person, the person seeking to be excused from performance, must have taken reasonable steps to avoid or to mitigate the event or the consequences of the event. So there are a number of fact-specific things that you're going to want to consider. So the facts of this are going to be very important in determining whether or not you have a sufficient basis for avoiding a contractual obligation, avoiding performance under a contract. It's going to be dependent upon the precise terms of the contract, and is also going to look at the specific context in which you're seeking to assert the provision. So those are things that I would keep in mind as you consider whether or not to assert some of these, to assert that type of provision in attempting to avoid performance under a contract. So with that, I think I'll kick it back to Ed Enoch, and if there are any questions, we'll do our best to answer your questions.
Well, Ed, one of the things, if you would talk a little bit about, I think we've both had a number of people come to us and say, I'm really concerned about allowing the public into my space because I'm afraid that I'm going to get sued if they get the virus and they're going to claim it came from me. What's your assessment of how hard is that going to be? How likely is it that those claims are going to be successful?
Well, I mean, I can't predict or make a prediction as to whether or not those claims will be successful, but I can tell you that from the standpoint of my experience, they would be very difficult because there's so many potential sources of the virus. To date, I'm not aware of any tests or circumstances where you can identify the exact source of the infection. I know we have all seen, one that comes to mind for me is on the national news for several days, they ran a video of this bus driver who specifically points to a lady that got on his bus and she sneezed without covering her mouth. He subsequently acquired the virus and he died. And that's a horrible story. But I think from a scientific standpoint, to be able to prove that he was exposed from that particular lady resulting from that sneeze would be very difficult. Not saying that it's impossible, but I think it would be a huge mountain to overcome. Another thing that Ed and I have received calls about are employees of businesses that are determined to be essential, and they are going to work every day, but it doesn't alleviate the business owner from complying with the social distance requirements and other safeguards that are designed to keep their employees safe. And when we've received some calls from employees who were concerned about what they can do if their employee is not complying with the recommendations or is not taking the adequate steps to provide for their safety. And even one employee who was concerned that that he had been may have been discharged because he actually reported his employer for failing to comply with the shelter-in-place orders. There are a number of concerns that employers should have. We haven't. I have not seen any cases yet where, and certainly no cases have been resolved where an employee has reported an employer for failing to comply with the shelter-in-place provisions. But I think that there are cases that can be made that if you intentionally ignore or disregard the safety of your employee and you take action, negative action against an employee for making a report to you, complaining to the employer, to the business owner, or complaining to, in this case, the Georgia Patrol about failure to act, that there could be some potential liability there. But I would certainly think that the facts of the situation would be important. And again, I would certainly consult with legal counsel or some other professional before you make that determination.
Blair, we have some questions.
Yeah, so if you all would like to send over any questions that you may have, again, realizing that Enoch and Mr. Ed Tarver are unable to answer specific questions regarding your situation in business. If you would like to ask a general question, we will submit that information over to them for them to answer. And then we will also be, of course, sharing this webinar on the end of it. So moving into tomorrow with our email communications, we'll be sharing the recording of the webinar. Again, it will be on our website, hosted on our Achieving More Today section for you all to reference or share with clients and associates that you think may find it beneficial. While we're waiting for questions to come in, I hope you will plan to join us on Thursday's webinar. We will have representation from the Department of Labor talking about unemployment claims. We will also have a member, actually owner of Loop Recruiting, talking about displaced workers. We will also have a representative from Cytel, who is a local business that's actually hiring. So we'll have a presentation for our webinar series this Thursday on those three components. And we will be happy to have you join us again then. Have we had any questions come through?
I see that we have one coming. I think this is one for Ed Enoch, if you can see it.
Yeah. Well, I see one that, oh, I see a couple of questions here. Let's see what I got. So the first question that we've got is, you know, what kind of record keeping do we anticipate we're going to need to do to keep track of the money on the payroll protection loans? And yeah, I would hope that if you are a small business and you have taken this loan, that you have a CPA, you have an accountant that's helping you navigate this. I just was dealing with a client yesterday who has gotten one of these loans, and you know, the banks, all their focus has all been on how to get the loan for somebody. They really haven't focused on, they haven't had time to focus on, none of us have, what happens once you get the money, how you make sure that you're tracking it. I think it's a good suggestion to put that money in a separate account and be able to account for whatever you're taking it out for out of that separate account. Because you just mix it up with the rest of your money, how are you going to say? Yeah, I think ultimately we don't really know what proof the government is going to ask for at the end of this 8 weeks, because they don't know yet. They haven't given us any guidance on it. So yeah, ultimately, if you got a loan of $100,000, just so we make the numbers easy, I think really all you're going to have to show is that you spent 75,000 of that on payroll. But I think the liability, the potential gotcha here is there's a very specific definition of what payroll costs are in that law. And there are things that a normal small business owner thinks of as being included in payroll, such as federal taxes on the wages, the FUTA and SUTA, that are specifically exempted. They don't count. So you really need, I think you're really going to need your CPA to help you make sure that you are getting the right numbers. You know, rent, utilities, the questions about, I mean, rent's pretty straightforward. I mean, you rent or you have a mortgage and you pay the interest on the mortgage, that's going to be covered. Utilities, the questions are, well, what's, you know, is internet included? Is my cell phone, you know, included? We don't know yet. We're still waiting. So right now, the SBA is so busy trying to get this money into people's hands, they really have not taken the time and haven't had the time to give us guidance on how to spend it.
All right, I believe we have two others, if you have a chance to pull those up.
Yeah, I'm looking at this one about hazard pay. So the question is, if a company has decided to pay certain employees hazard pay, how does that work with regard to other employees? I don't think that there's any problem with you know, a company identifying people who are maybe on the front line. I mean, we don't know what the situation is, but let's just take a hypothetical. It's the folks that are working the registers at a grocery store. You know, maybe that's somebody that you decide deserves some extra pay because of their extra risk. That's not a problem. If you're relating it back to the payroll loans, the question is going to be, you know, you've got to pay everybody. You've got to maintain your payroll at the level that it was at in one of two very specific periods, and you can only cut any individual's pay by 25%. So if you are, you know, bumping some pay for hazardous pay, again, you're just going to have to make sure that mix turns out to still satisfy the 75% and doesn't penalize anyone more than 25%. And if you miss those numbers, what's going to happen is just part of your forgiveness is going to go away and it's going to get turned into a loan. And so this third one, everybody wants to talk about employees. What is the difference between furloughed, laid off, and whether a commitment is made by the employer to return to work? So I think the difference between furloughed and laid off is, you know, if you're being laid off, that is without an intention that the company is going to continue to be related to you, that you're going to be anticipating coming back. Really, there is no legal, those words don't have any legal significance, furloughed or laid off. What the Department of Labor is looking for is anybody that the employer or either reduces their compensation or reduces their hours or completely sends them home, whatever you want to call that. It's up to the employer to make that claim, and the employer has to go on and make the claim for the employees every week. Now, if you fire somebody, I mean, if you terminate them because they're working and you know, they're not meeting your expectations, just like any other normal time, that's different. I mean, you don't have an obligation to report that person. It's only if you're reducing their hours because of the virus. Yeah, Blair, one of the things, and as we wait for more questions to come in, one of the things that I'm seeing, and I think we're going to see a lot with this payroll protection loan, is everybody's going to have to get put back on the payroll, you know, basically at full pay. And you're going to need to do that as an employer. You're going to need to do that for 8 weeks. That's the time period that you have to spend this money. While nobody has gotten the $600 unemployment yet in the state of Georgia, it's going to come. and it's going to be backdated to whenever they legitimately first had an unemployment claim. What we're finding is a lot of folks are making more money being unemployed than they were going to be making if you put them back on the payroll. And so I've had employers ask me, well, what do I do? What if they say, well, I don't want to come back. I just want to stay on unemployment. Well, that's not an option. If I'm an employer and I have the money to pay you and I'm telling you I'm going to pay you, then if you don't come back, then you've abandoned your job. You're not going to get the $600 unemployment kicker.
So just curious, in that example, what is the process for an employer to not be held liable for continuing to pay unemployment, given that the employee has refused to come back with his willingness to put him on payroll?
Well, so this is this is all uncharted ground, but I think my advice would be that just like you would separate anybody. If somebody says, if I say I've got work for you to do and they say I'm not coming to work, well then you send them a DOL 800, a separation notice, and say, okay, well you're abandoning your job, and at that point I think the obligation for the employer to report that person's unemployment weekly ends, because you don't fit the category anymore. That'd be a good question to ask your Department of Labor person on Thursday. See how they see that playing out.
Right.
We
Thank you.
Just hypothetically, because very few people have gotten the money yet.
Right. We've had one or two more come across.
Ed, did you see that question? I think that
I see the question that says, if a consumer/employee is exposed or a liable situation arises, but action is not taken immediately by the exposed party, would you recommend consulting legal counsel immediately or try to handle internally yourself? And that's a toss-up. Being that I'm a lawyer, I'm going to always recommend that you consult legal counsel as soon as possible. I'm sure that whatever counsel you consult with is going to want you to preserve some information. I mean, the concern that you're going to have is that you want to have sufficient information available to defend against the claim, should that exposed person ever make a claim of liability against your business or against you individually. And so discuss with your legal counsel the records, the information that you have recorded, preserved, that you can use to clearly address the situation under which the exposure took place, whether or not you as the employer or the business owner was in compliance with whatever provisions were in place at the time, and that you were complying with exercising ordinary care and keeping the premises and keeping the environment safe for either the employee or the customer.
Looks like we have one or two more.
I think this is relates to the last question. It asks about the 2-year statute of limitations, and until we get other guidance, we're going to have to assume that the limitations periods that are in place now are going to apply. Generally, as it relates to a personal injury of that type, it's a 2-year statute of limitations from discovery, and that's going to be that may be a difficult question, because with the coronavirus, with COVID-19, you have such a long incubation period. When do you start the clock? When the person first recognizes that they have a fever, or when they're able to get tested, or when the test results come back. So there are going to be a lot of questions. There'll be questions that I'm sure may come out of that, depending upon how long they wait in order to exert their claim. So again, that just kind of drives home the reason that it's so important for you to keep accurate records and to preserve as much information regarding that particular individual as you can.
Well, and right now, I mean, none of the courts are functioning. All of the limitation periods have been stayed, and so part of the difficulty is, well, we don't get fast answers through the legal system anyway. I mean, when you're trying to resolve an answer through the court, you're talking about years, not days or weeks. And so, we just have to, employers and just have to do the best they can to anticipate what's going to happen. And as Ed said, to make sure they keep a good record of what they have done, what preventive measures they've taken, how they've reacted to people when they know that they've got an infected employee. Record keeping is key. If you didn't write it down, it didn't happen. That's what I think I learned in the Navy. I expect that Tarver got the same thing in the Army.
And you see this final question, this last question?
Let's see.
Yeah, I think it's either one of us could handle it.
Yeah, go ahead. Oh, you want to talk about temperature testing? So that's that's something that's typically not allowed on a general basis to do temperature tests on everybody that comes in. But the EEOC is specifically, and the CDC, in cooperation with the CDC, has specifically said during this pandemic that is fine. Yeah, I don't know that I would go to the point of rewriting my handbook. I think I would just make an addendum or make it clear to everybody that those are going to be the conditions to return to work. Because as a general rule, that's not going to be true. You're not going to be able to just test people for health reasons once this pandemic passes.
Do we have any others, or does that cover it all for us up to this point?
That's all I see, Blair.
Well, as always, we appreciate your expertise and your taking your time to share information. We will provide, as I mentioned, the recording of the webinar as well as Mr. Enoch and Mr. Tarver's contact information should you have questions following the webinar, and we hope to be joined back with you on Thursday. Thanks again, Enoch Tarver Law Firm, for the presentation today, and everyone enjoy the rest of your afternoon.
Thank you. Thanks for the opportunity, Blair.